rental value for a month, 6 months, or whatever. And indeed, again, the loss of use coverage deed will cover that loss of rental value too. Coverage deed, for the record, is approximately, is usually about 30% of the coverage limit. All right. Well, I know you're getting tired of hearing my voice, so at this point, John is going to conduct our second poll on what we just talked about here.
Thanks, David. All right, put on your thinking caps. Which Section 1 coverage would respond to windstorm damage to a swimming pool that is separated from the house by a walkway? Would it be underdwelling, other structures, personal property, or loss of use? Please pick your answer. We'll give you about 30 seconds, and then we'll come back and report on that. And the results are coming in, and here they are, David. Let's see. Nobody thought it was covered under the dwelling. 4, or 31%, thought it was covered under other structures. No one thought it was covered under personal property. And 1 person thought that it was covered under loss of use. So what does it look like, David? Other structures is the winner here?
Yeah, that is the winner, and that is indeed the correct answer. So the key here is that the swimming pool is separated by the house, separated from the house in a significant way. It's just a walkway, so it's not attached to the house. And so at that point, the coverage would be under the other structures. And so I'd like to point out that about 80% of the answers, you got that right. So I think we're doing a pretty good job at this point. All right, moving forward, Section 2 of the homeowner's policy then just covers liability and medical expenses associated with potential losses resulting from the home. The first coverage in Section 2, coverage E, covers any sort of third-party liability arising from home ownership, and in fact, it's a little bit broader than that, and in fact, the coverage is referred to as personal liability coverage. So, yes, this will provide coverage for any situation that the homeowner becomes legally liable for loss that happens inside the home, whether it's a slip and fall. Again, a roofer perhaps falls off the roof while installing, while repairing the roof. If the homeowner is liable for those losses, this liability coverage, Section E, will provide coverage for the homeowner. But it is a little broader than that. Again, as the coverage is actually called personal liability, so it provides a bit broader personal liability coverage for the homeowner, even if it's not specifically having to do with the home. So examples may well be a child throwing a baseball through a neighbor's window, or perhaps a dog biting someone at the dog park. All of these would be covered under the personal liability coverage of the homeowner's policy. In addition to paying for any losses that the insured becomes legally liable or legally responsible for, we'll point out that the liability coverage in the homeowner's policy also obligates the insurer to legally defend the insured. So as long as the limits of the policy are not exhausted, the insurer has to provide for legal counsel and these sorts of things under this liability coverage. The standard limit here is $100,000. Again, as with everything else that we've mentioned, all of these limits can be changed as necessary and as needed by the insured. The final primary coverage part of the homeowner's policy is Section F, and that is referred to as medical payments to others. Here, again, we're talking about a third-party claimant, so neither the liability coverage nor the medical payments would pay any medical payments to the homeowner themselves or homeowner's family member. Rather, these are for third-party claimants. The medical payments are designed to pay relatively minor losses. Typical limits are $1,000 or $5,000. Again, typically rather minor medical payments, medical expenses. The idea here is to avoid court, avoid litigation. So to that end, these medical payments are made regardless of fault. So the homeowner does not here have to be legally responsible or legally liable for the loss, and indeed the insurance policy will still pay. Again, the idea is to simply try to avoid the burdensome legal process. All right, well, that's it for the primary coverages of the homeowner's policy. There are a couple of options that we're going to mention here with respect to homeowner's policy. The first of which is that the homeowner's policy is actually somewhat mislabeled, and that is to say you don't actually have to be a homeowner to have a homeowner's policy. So in fact, sure, some of the standard insureds will be those that actually own the home and occupy the home. We might refer to those as owner-occupants. But tenants, so those that are just leasing or renting a property, as well as condominium owners who don't own the full building but own only their unit, can also find coverage in a homeowner's policy. And we'll show you a few of the different homeowners policies and some of the combination of options here in a second after we finish this second option choice, which is the peril. So in insurance terminology, perils refers to the cause of loss. So these are the fires, the wind, the flood, these sorts of things that might cause a loss. And virtually any property policy, what you see is the perils handled in two different ways. It's either done on a named peril basis or an open peril basis. The named peril is exactly what it sounds like, in that they will list, the insurance policy will list the exact perils that are covered under that policy. If the peril is not listed, it's not covered. Now, to be fair, if you ever go and look at a policy, you'll see that it's not just a list of perils and then they stop. And indeed, there's a lot of discussion as to remaining as to what's not covered, and in certain situations when covered and non-covered perils happen. But at the basis, this named peril agreement basically just lists the perils that are covered or not. The other option that you see in property policy are what they call an open peril agreement or an all-risk agreement. Here, instead of listing the perils that are covered, the insurer lists the perils that are not covered or that are excluded. And these open peril agreements are typically thought to be broader in the sense that if the peril is not excluded, then by definition it must be covered. Right? And so these are oftentimes more insurer-ed-friendly types of forms, and they're not uncommon in property coverages. Just to be clear, most of your standard homeowners policies are going to cover standard perils, fire, wind, hail. Most are also going to exclude those catastrophic perils that we hear about in the news all the time, floods and earthquakes most prominently. All right. The next two slides then sort of show so some of these owner or non-owner, if you will, and peril combinations. So this first slide here shows a handful of the different homeowners forms for those owner occupants. The HO3 is probably the most common.